The U.S. Department of Homeland Security and the State Department issued new public charge regulations, which went into effect on February 24th, 2020. The new rules will make it more difficult for less wealthy people to qualify for either temporary visas or for green cards, or if the people are already in the U.S., for them to change or extend their temporary status. The applications and petitions that were pending, though, on February 24th, 2020, will not be affected by the new standard. In my opinion, the new regulations are probably the biggest change in immigration procedure in the last 50 years. There's been a public charge rule in the immigration law for decades. It's Section 212A4 of the Immigration and Nationality Act, and what it says is that it only applies to persons who may become primarily dependent on certain public benefits for over half of their income or support. What the new rule does is it broadens the number of categories that are considered public charges, and it says if people are more likely than not to receive 12 months of public support over a 36-month period, they're inadmissible, unwelcome to come to the United States. We don't think that most people who are immigrating through their employment will be affected by this, but people in the family categories or in the DV lottery will be most affected. With the new rule, immigration officers will concentrate primarily on the following 5 factors: the person's age, their health, their family status, their assets, resources, and financial status, and their education and skills. Regarding age, persons who are 62 years old or older will need to demonstrate why their age will not impact their ability to work. For health, applicants will need to show that their medical conditions will not affect their ability to work and care for themselves. As far as family status, the applicant's household includes dependents and persons providing the applicant with more than 50% of support. With regard to assets, resources, and financial status, the question is whether the annual household income is at least 125% of the federal poverty guidelines. The examiner will look at the financial status of the person, and that will be measured by civil liabilities, credit history and credit score, past applications for or receipt of public benefits, an application for or receipt of a fee waiver for an immigration benefit. And that's only immigration fee waivers on or after February 24th, 2020. As far as education and skills, the examiner will look at whether the applicant has adequate education and skills to obtain lawful employment with an income sufficient to avoid becoming a public charge. They'll look at your employment history, education level, occupation skills, and licenses. Also your English proficiency and the status of the applicant who is a primary caregiver to another individual who's in the household. Prior to the new public charge rule coming into effect, there were only 4 programs that the immigration system looked at to determine whether you might become a public charge, and those would be the receipt of Social Security income, SSI, temporary assistance for needy families, state general relief or assistance, or a Medicaid program that covers institutionalization for long-term care. The new regulations add a number of other programs to what would be considered public charge. The first one is food stamps or SNAP. Also non-emergency Medicaid, although there is an exception if it's for children under 21 years old or for pregnant women, including 60 days postpartum. Also for public housing and Section 8 Housing Choice Voucher Program and project-based rental assistance. Now, who is affected by the new public charge rule? Anyone applying for a temporary visa to come to the U.S., or anyone who's here on a temporary visa who wants to change their status or extend their status in the U.S., people who are applying for green cards, applicants for adjustment of status. So when I say green cards, I'm talking about people going to their U.S. embassy or consulate in their country to get a green card, and adjustment of status, meaning getting a green card in the United States. And it's important to know that there's two sets of regulations, although they're very similar, one by the USCIS for people getting benefits in the U.S., and one for the Department of State for people applying for visas abroad. It's also important to know who's exempted from the new public charge rule. As I said in the past, people who applied for benefits, even though they're on the waiting list to get their interviews or to hear about the decision on their application before February 24, 2020, are exempt from the new rule. Also, green card holders. If you already have a green card, whether it's a 2-year or a 10-year green card, you're not affected by the new rule. However, there's one exception that applies to very few people. If you are on a green card and you take a trip out of the U.S. for 180 days or more, and then you re-enter the U.S., you become somebody who is no longer exempt from the public charge rule. Also, we've been getting a lot of calls from people who are applying for naturalization, who are necessarily green card holders, worried that some public charge relief that they got years ago, months ago, days ago might inhibit them from naturalizing. And the answer is, as far as applicants for naturalization, they are not affected by the new public charge rule. Other people who are exempt from the public charge rule are special immigrant juveniles, people with T status, which are victims of human trafficking, U status, victims of crimes, persons with VAWA, NACARA, or registry, persons with the Cuban who have got benefits under the Cuban Adjustment Act, and applicants for TPS, or temporary protected status. On February 24, 2020, the Immigration Service introduced 3 new forms which didn't exist before. People who are applying for adjustment of status will now be required to submit an I-944 form with their application for adjustment. It's a new 18-page form. It has 16 pages of instructions, and the 5 factors that I mentioned in a previous slide will all be asked about in some detail, so the government can determine whether, based on the totality of circumstances, they believe you would become a public charge or not in the future. Finally, there are 2 forms, the I-945, the public charge bond, and the I-356, which is a request for cancellation of a public charge bond. I should also mention that the government updated a number of forms that must be used starting February 24, 2020. You can't use the old forms anymore. It's non-immigrant petitions, applications for adjustment of status, the affidavit of support, request for fee waivers, waivers of inadmissibility, which could be for unlawful presence, for fraud, for criminal activities, and applications for either an extension or a change of status. Finally, remember that the officers have tremendous discretion, and we're talking about people who might become a public charge anytime in the future, a month, a year, 10 years from now. So sometimes it's very difficult for the officer to, know what the future is going to bring. So they've established something called a public charge bond, and that's something that a person can put up a bond to assure the government that they're not going to be reliant on public charge. Right now, the minimum bond amount is $8,100, but it could be significantly higher. And the bond is breached, meaning the government gets that money if the person becomes a public charge in the future for at least 12 out of 36 months. We hope this has been helpful in having you understand what the public charge rules are about, how the new rules might affect you and your family. If you have any additional questions, feel free to schedule a consultation with one of our attorneys. You can call the 800 number to get some information. It's not my personal number, but if you look online, we supply a lot of information about the public charge bond, and we're here to help you.